Hi, welcome to another episode of Your Skogans, the International Law Podcast. Today we are joined by Dr. Danae Azaria to discuss her article titled Codification by Interpretation, the International Law Commission as an Interpreter of International Law, which was published in the European Journal of International Law. Dr. Azaria is an associate professor at the Faculty of Law at University College of London. In addition, she is a senior Humboldt Fellow of the Alexander von Humboldt Foundation at Humboldt University in Berlin and the principal investigator of a starting grant of the European Research Council funding her current research on state silence. Dr. Azaria, thank you so much for joining us. As the elections for the ILC get closer than ever, I thought it would be useful to explore the role of the ILC in greater detail, particularly with regards to interpretation. So just to roll off the discussion, could you, for the viewers who may not be familiar, discuss the mandate of the ILC and what role does it play within the sphere of international law?
Thank you very much for inviting me. It's a pleasure to be here today with you. And also, indeed, very exciting times. Looking forward to the results of the elections in 2 days from now. So what is the International Law Commission? The Commission is a body of the United Nations composed of 34 experts in public international law. And this body, which is a subsidiary body of the UN General Assembly, is mandated with the codification of international law and its progressive development. The Commission has been instrumental in developing the framework of international law as international lawyers know it today, especially with its work on the law of treaties, the law of the sea, state responsibility. So in the previous century, the Commission has followed the codification by convention paradigm. It mainly prepared non-binding texts, but these texts were intended from their inception to be the basis of future conventions. In other words, treaties that will be concluded between states on the basis of multilateral conferences. Often these were taking place under the auspices of the United Nations. And this paradigm was the standard way of developing and codifying customary international law, especially in the previous century. And I think in this context of lawmaking, state consent was really preserved significantly through negotiations. The formal rules also of expressing consent to be bound by multilateral treaties made sure that state consent was preserved as well. And also the rules on entry into force of treaties did the same thing. To some extent, state consent was implicitly preserved even vis-a-vis the development of customary rules, because the belief of law opinio juris, which is necessary for custom identification, was still to be found in the process of interstate negotiations, or at least after the conclusion of a multilateral treaty. Which was based on formal consent, at least on some first level. But I think in recent years, we have seen now a shift in the Commission's role towards a much more modern function, which we have to say that it has been contested fervently in the past decades, especially by governments, because international law has witnessed a devastating, perhaps we could say that, fall in multilateral negotiations and multilateral treaties, while at the same time international courts and tribunals are increasingly relying on the Commission's non-binding outputs, especially with the implication rather that they are bypassing state consent in the production and development of international law. And so I think this is a very important research in that it deals with how international law can develop through the interpretation of treaties and of custom, and what is the role of the Commission in this particular operation.
So in your article, you term this modern approach of the ILC, so to speak, as codification by interpretation. So we'll come to questions of consent and how it's, the state consent is being bypassed in this particular context, or arguably so. But what exactly do you mean by the term codification by interpretation? So to break down the words, what exactly does the term generally mean, and what do you what in your mind is interpretation? For example, how does it differ from rule ascertainment, application, amendment, or modification?
So interpretation, I'll try to be as short and brief as possible. So interpretation means determining the scope and content of a rule or text, so determining meaning. Ascertaining, of course, as a process, interpretation, determining meaning, is different from ascertaining whether a rule already exists in the first place. Two different processes, very different functions, and different rules apply to them. In terms of application, of course, application and interpretation differ because application is concerned with bringing about the consequences of a rule to the particular facts of a case. So it is different really from interpretation, in that interpretation simply is explaining the meaning of a rule rather than bringing about the consequences of the rule. Modification differs, an alteration of the rule differs from interpretation in that you have, for modification, you have, you're going beyond the initial intention of the parties completely, and you're changing the meaning rather than trying to understand the meaning or determining the meaning that was initially intended by the parties. I hope that this clarifies things. So what I mean by, yes, sorry.
So it does clarify it. And normally when we think of interpretation, we always come back to Articles 31 and 32 of the Vienna Convention on the Law of Treaties. But what role could the ILC play in terms of interpretation of custom? Is that a role that the ILC plays? And if so, how would you interpret custom, or how would you look at that?
This is a very interesting point, in fact. The first question to ask before that is whether custom can be interpreted and can it be subject to interpretation. This is a very big discussion, obviously, theoretically. Some authors and scholars are completely against the proposition that custom can be subject to interpretation as separate to the process of ascertaining it. And this is because of the unwritten form of customary international law. It's not comparable to a treaty text. On the other hand, my view implicit in this article, because I did not specifically address this point, is that perhaps what we are witnessing is that where we are today in international law is that custom can be interpreted in the sense that we can determine its content. The problem is rather that we do not know as yet what the rules for determining content are, as separate from ascertaining it in that sense. The International Law Commission in 2018 adopted its conclusions on custom identification. There the Commission is really not distinguishing between ascertainment and determination of content at all. In fact, it considers both of these as falling within the term identification. And then, of course, because the Commission systematizes a method for identifying custom, it gives the impression that it has simply rejected that there's a separate process for interpreting custom. Of course, in its previous work, the Commission has indicated that there may be specific elements for custom interpretation. For instance, the object and purpose of a customary rule. The Commission has referred to that as an element for interpreting custom in its articles on state responsibility, as an example. So I don't think that we have let's say, closed this subject. I think it's an open subject for a lot of debate in the future.
That's a very interesting point. So just to move further, so you mentioned that the ILC has sort of shifted its approach. It's now going into this codification by interpretation role. What specific examples can we look into when we think about codification by interpretation at the ILC?
Yes, I suppose the examples I used for this particular article come from the area of the law of treaties. And I've chosen this particular treaty to demonstrate a particular paradigm that is developing. We're talking, just for those that are not familiar with the law of treaties as yet, we're talking about an area of customary international law that has is systematized in the Vienna Convention on the Law of Treaties of 1969. I consider this as literally the prime example of codification by, first of all, convention. And then today, many of these provisions in the Vienna Convention are widely accepted by states and international courts and tribunals, but also scholars as reflective of custom. Since the early 2000s, the Commission has returned to the law of treaties. And by that, I mean that it has undertaken work in 4 topics, where it is preparing documents that are intended to remain non-binding. And through these documents, conclusions and principles, it has guidelines, apologies. It has endeavored to fill gaps and also has interpreted this treaty in force, the Vienna Convention on the Law of Treaties, and has also, through that, developed custom that is set forth in the Vienna Convention on the Law of Treaties, but also beyond it. I could give you some more specific examples within possibly the Vienna Convention, if you would like.
So if, for example, you could touch upon jus cogens, because I think in terms of when we talk about state consent, jus cogens is definitely one of the topics that I would think, is much more intensive, if that's the right word. So maybe if you could just give us an example of how the ILC did codification by interpretation there.
Yes, so first of all, just to give an overall context, of course, the 4 topics that I have identified as relevant for the codification by convention, codification by interpretation paradigm are the work on the guidelines on reservations to treaties, the conclusions on subsequent agreements and practice in relation to the interpretation of treaties, the guidelines on provisional application of treaties. All these works have now been adopted by the Commission on second reading. And also the conclusions on identification of peremptory norms of international law, jus cogens, as we suggested. This topic has only been adopted on first reading this year, and next year the Commission will be considering it on second reading. So for that reason, it is also, there is an extra level of interest besides the importance of jus cogens within the international legal order. An example from the jus cogens topic is the meaning of peremptory norms of international law. Article 53 of the Vienna Convention on the Law of Treaties sets out a definition of jus cogens norms. And to the extent that the Commission actually clarifies this meaning in its conclusions on jus cogens, it is also interpreting the Vienna Convention on the Law of Treaties. Another example that comes perhaps from, let me give you the classic example would be from the guidelines on reservations to treaties. The most important controversy about reservations is whether reservations that do not meet the requirements of Article 19 are permissible or impermissible, and if impermissible, they are invalid, or whether they are subject to objection or not. So what the Commission has done in the, this is, of course, this controversy is due to the fact that Articles 19 to 23 really do not clarify this issue at all. They leave it, they're silent on what happens when a reservation is made that does not meet the requirements of Article 19 of the Vienna Convention. So what the Commission has done with the guide to practice on reservations to treaties, and you can, this is very evident in its commentary, the process of doing that, it has come to the conclusion of saying, well, actually, under custom, and not within the convention, but under custom, impermissible reservations are invalid and void. But to reach this conclusion, the Commission first interprets the Vienna Convention and says and finds that through effective interpretation, Article 19 does not deal at all with the issue of the effect of impermissible reservations, and articles, reading together Article 19 and 23, as well as taking into account the preparatory works of the Vienna Convention, it concludes that this issue is left outside the Vienna Convention. And then it moves on to identifying customary international law. But to reach that point, the Commission had to first say that there is a gap in the treaty. And even to find that there is a gap in the treaty, it had to interpret that treaty. And that's an example of an interpretation.
That's, I think, a really interesting point, because it just, when the Commission goes into sort of this investigatory role, it just almost feels as if, for example, the International Court of Justice is looking at the rules to interpret and apply it for the states. So then that sort of brings me back to the point that you mentioned on state consent, and whether really the ILC has the power to look at the rules as they exist and then give their opinion on it in terms of, not in terms of the conventional sense of, progressive development or codification, but in terms of interpretation. So can we at all derive this mandate of the ILC from, for example, the ILC statute, the preparatory work? So is this work of the ILC permissible, if for lack of a better terminology?
Yes, so essentially your question is whether interpretation as a function, as an operation, falls within the Commission's mandate. Does it fall within progressive development or or codification of international law, or is this beyond its mandate? And I think, there are, I think this is at first glance, perhaps someone might think, I mean, this is really basic, right? Why are we even asking it? But I think it's extremely significant. I think that, first of all, it's significant because there are scholars that have taken the position that different works of where the Commission is interpreting do not fall within the Commission's existing mandates. And I think even more crucially, because international courts and tribunals, and especially the ICJ, give significant attention to the Commission's pronouncements, states might endeavor to downplay the Commission's interpretative activity by criticizing it specifically as falling outside the Commission's mandate. And I think that's why this question is particularly important. Yes, there are ways of trying to limit and constrain the Commission's power, but this is not the right way. This is essentially what I'm saying. I think it is better to be done through scientific methodology, requiring the Commission to be very rigorous in its interpretive ways, rather than arguing that interpretation falls completely outside its function. So I disagree with the proposition that interpretation is beyond the Commission's existing mandate. What I argue is that there's not, first of all, there's nothing inherent in interpretation that precludes the Commission from interpreting, and that both the mandates of the Commission, both progressive development and codification, in the way that they are defined in the statute of the Commission, may cover interpretation. But I think what I am also very reluctant about, and I've rejected in my article, I don't think that we can classify interpretation necessarily only as codification or as progressive development. Nor am I, of course, suggesting that one interpretation by the Commission necessarily falls within, it's both progressive development and codification. Obviously, that would be very confusing and it would not help in the stability of law. But what I'm suggesting instead is that each interpretive pronouncement of the Commission has to be assessed individually so as to determine whether it falls within codification or within progressive development. And in order to do that, of course, we need to be very aware of the four different categories that we have under the subcategories that we have under the two categories of codification and progressive development. But we need to also be very clear about the particular pronouncement of the Commission.
That's quite interesting. So the sense I got from reading your article was that this mandate has not really been consciously thought through, but just that the ILC started delving into this function and very subconsciously it just started to interpret the law. So And then we see state responses where states have been, and more often than not been as active in terms of seeing, oh, is this the wrong approach? Is this the right approach? So it just feels like it has in many ways slipped through the cracks, and this is happening, but no one's really thought about it. So it's just happening very subconsciously. So give us your thoughts on what you think, or whether the ILC has made this conscious decision or a subconscious one.
Okay, I don't think I can actually talk about the subconscious of the commission. We could try to psychoanalyze the commission, but I don't think we're there yet. But I think it's very clear that the commission does not have a specific official policy, let's put it this way, of working method in relation to interpretation. So it has not done that. In my research so far, for this work, for this article, which of course included much more examination of the practice of the commission, as any written work of course does. But in my research, it is very clear that the commission is not always clear, explicit, rather than clear, explicit what method of interpretation it is using. That is not necessarily suggesting that the commission does not apply methods of interpretation. It may do so, but it is not stating that necessarily. Having, of course, observed the commission since 2013 in person in Geneva for each session for this research, I can tell you that, and that's completely anecdotal and empirical, right? That the discussions are very thorough and they do involve consideration of what a usual interpreter would take into account, indeed. But there are no express references to this effect within the commentaries. And I think that it's, given that the commission is increasingly using interpretation, and of course these 4 topics that I just mentioned are just examples to make the point, but interpretation takes place in pretty much every work of the commission. Examples of its current work, even the more primary rules that it's looking at, for instance, the effects of armed conflict, the effects, armed conflict and the environment, the principles on armed conflict and the environment, involve a lot of interpretation of different humanitarian law treaties or customary international law as well. And in fact, the special rapporteur for that topic, Maria Leto, who also responded in a blog post to my article, makes this a very point that her topic really does what the article suggests that the commission is doing. So I think, given that the commission is increasingly using this method in its reasoning, and I think this should be also something to remember, this is a matter of reasoning, the commission should be a bit more explicit and more conscious of what it's doing, you're right. So more clear about its method. And I think that falls also within my wider work about the commission's working methods, the commission's nature as a scientific body, as an expert body, which means that its work and persuasion, its work has not because it's binding, as we want to discuss later about the effects of the commission's work. It's not by itself binding, but what is persuasive about it is the method that the commission has employed, how rigorous it is. And when we talk about being rigorous in terms of analysis, we mean methodology, scientific methodology being employed in a consistent manner.
This is really interesting, but that answers sort of one part of the equation on how the ILC perceives it. But then once the ILC starts going into codification by interpretation, then you have states. And then states have thus far not been critical, or in fact have been silent, if you will. So what legal significance should we attach to this silence, and whether even states ought to respond to the work of the ILC, or whether they're legally obligated to do so? Because state silence, to my understanding, or rather very basic one, is very interstate in nature. So should the ILC's codification by interpretation role prompt responses from states?
Yes, I think that's a very important question, in fact, and I don't think necessarily it is constrained to and limited to the issue of codification by interpretation. It is a more general question about whether the states are expected to react to the Commission's work and whether the absence of their reaction to the Commission's work can be taken as opinio juris for custom identification. In our case, of course, as far as interpretation of the Vienna Convention as a matter of treaty law is concerned, we are really concerned about about the rule that is set forth in Article 31.3b of the Vienna Convention. In other words, whether the subsequent practice that establishes the agreement of Vienna Convention parties to the interpretation of that convention by the Commission, essentially. And of course, at the same time, custom as well. These are two operations that are taking place in parallel because some of the provisions that we're looking at are customary rules. But just to give some context a little bit so that everyone also understands, silence of states is a fact. So it doesn't by itself produce a legal effect. It can have legal significance when and under the conditions that international law indicates that it does have this legal significance. And indeed, under international law, in order for state silence to have some legal significance, a few specific conditions have to be met. First, we need to have circumstances that call for the reaction of a state, and the silent state is in a position to react within sufficient time. And this position to react also includes knowledge, being aware of the circumstances that call for one's reaction. Now, you're asking me whether the Commission's pronouncements, in this case, interpretative pronouncements, are circumstances that call for the Commission's reaction, and whether states are being silent vis-a-vis the Commission's pronouncements, have they been in a position to react? So let's first look at the condition of knowledge. Are states in a position to react? The requirement that a state has knowledge of the conduct that calls for reaction in this scenario can be met, I think, because the Commission's work is made public to UN members through the UN Secretariat. So that is met. Now, the problem, as you rightly immediately picked it up in your question, is really whether the Commission's pronouncements per se, on their own, are circumstances that call for the reaction of states. And I think that given that the Commission has no specific mandate concerning a particular treaty or a customary rule, it is difficult to argue that its pronouncements are circumstances that call for the reaction of states. Additionally, I think that the argument that the Commission's pronouncements call for the reaction of states would entail a system of interaction between the Commission and governments that is an opt-out system. In other words, states would have to oppose in order not to agree to the Commission's pronouncements. But I don't think that there is any evidence that this was intended to be the case, or that either states or that the Commission considered this to be the case. And also, whenever the International Court of Justice has relied explicitly on the Commission's pronouncements, there is no evidence that the court has done so because it has considered that states have acquiesced to the Commission's pronouncements. So no, I do not think that today we could say that the Commission's pronouncements per se call for the reaction of states in the absence of which their silence is taken as acquiescence.
So could it be, and you touch upon this in your article as well, could it be that there comes a situation where states nonetheless do start responding to the ILC statements to the point that it's very, very widespread, where states have begun reacting so much so that we're close, but not really there in terms of Article 31 subsequent practice? So then in those circumstances, could then the work of the ILC through states being a channel become a situation where finally a response is warranted in the context of, subsequent practice being developed with the agreement of all parties, so to speak.
Yes, of course, there the question is not so much whether the Commission's pronouncements are circumstances that call for the state's reaction, but it's the reactions of other states to the Commission's work that may constitute themselves then circumstances that call for the action of the rest of the states in the Sixth Committee or the UN members, basically. And yes, in that scenario, we can envisage, I think, a more nuanced approach where, of course, the silence will not be the only evidence that we will take into account. But I think we have to have some gradation in that context, because that these statements, official statements of states about what the position of the state of the law is. And so that's more intense interaction, let's put it this way, between states. But I suppose this is the wider background behind this, I think, is the fact that what the Commission does is to be a focal point. It's starting a debate constantly with states. So it is essentially triggering, it's making an offer of interpretation to states. And then that, because of the relationship that the Commission necessarily has under the UN Charter with the Sixth Committee, with the UN General Assembly, it starts a debate with states. And that interactive debate with states can lead to an agreement between states about the interpretation of the Vienna Convention or the content of custom.
So just to circle back to something you mentioned a while back, in the sense that codification by interpretation is not per se binding, that's I suppose fairly clear. But then what legal significance or importance should we attach to ILC's role, and where do you think it falls within the sphere of international law in terms of importance, in terms of significance, and in terms of just the legal value of it?
Yes, I think to some extent also my article is, I've seen it as a way of cautioning both the Commission itself, but also governments in avoiding to believe that whatever the Commission does is necessarily binding or conclusive. So what I have tried to do here is to implement positive law analysis in an effort to show that not even positive law would meet the requirements of conclusive interpretation in this context. So no, in my view, the Commission's interpretations, first of all, are not conclusive. They're not binding. They're not authentic in the sense that they do not fall within Article 31 of the rule that is set forth in Article 31 of the Vienna Convention. But as I explained, I think that they can trigger an interpretive dialogue with states whose reactions then can lead to authoritative, authentic interpretations within the meaning of Article 31. I think a separate question arises as to whether the Commission's interpretive pronouncements can be a supplementary means of interpretation. And I'm talking about the rule that is set forth in Article 32 of the Vienna Convention. I think this is a very important question. And of course, I think that we need to clarify one point. Yes, it is very well settled in the case law of the International Court of Justice and other tribunals that when the Commission's draft texts have led to treaty negotiations and the draft texts with commentaries form part of the preparatory works of that treaty, they are a supplementary means of interpretation. I mean, when the negotiators have taken into account the Commission's work, these are supplementary means of interpreting that subsequent treaty. And this is because they have been part of the documentation on which the negotiators have relied on for negotiating. But what we discuss here is completely different. We are talking about the Commission's interpretive pronouncements that have been subsequent to the conclusion of a treaty. And this is certainly not part of the preparatory works of the treaty, and here the Vienna Convention on the Law of Treaties. I think, however, that we could possibly argue that the Commission's interpretive pronouncements at least some of them, are may be a supplementary means of interpretation. The first point to make is that Article 32, the rule that is set forth in that article, lists non-exhaustive examples. So preparatory works and circumstances surrounding the treaty's conclusion are only examples, they're not exhaustive. And so it is conceivable that the Commission's interpretations are other supplementary means of interpretation. And I think one case in which the International Court of Justice may be seen to have relied on the Commission's work as a supplementary means of interpretation is in 2007, the Bosnia-Herzegovina versus Serbia and Montenegro case, where the court applied the 1948 Convention on the Prohibition of Genocide. So the Commission had not in that case been involved in the preparation of the Genocide Convention at all. But in order to interpret the Genocide Convention that the court applied in the case, it relied on the Commission's 1996 draft code of crimes against peace and security of mankind. And because it did so, one could argue that the court used the Commission's pronouncement in the Code of Crimes as a supplementary means of interpretation for interpreting the 1948 Genocide Convention. So I think that it is plausible that the Commission's interpretations subsequent to the conclusion of a treaty may be a supplementary means of interpreting that treaty. But I think we should also be very careful. I don't think that interpreters can rely on these without further consideration and filtering. First of all, we need to always remember that supplementary means of interpretation apply only when the conditions for them to then be applied exist. And beyond that, in any event, I think any interpreter would have to assess what weight it can give to a particular pronouncement by the Commission. And that will depend, in other words, on qualitative factors, including the methodology that the Commission has used to reach that particular interpretation.
So this is really interesting. Could we also, for example, one theory of the court applying the 1996 code in terms of the Genocide Convention, did you see this as a question of supplementary means of interpretation, or could perhaps it be seen as, sources of law question where, for example, maybe the ILC is seen by the court as, falling under Article 38, 1D of the statute? So do you see, how do you see it playing out in terms of the sources of international law? And then at the same time, could it be a supplementary means and the source of international law? So how do you see those two questions intersect?
I suppose what you mean is whether the Commission could fall within the subsidiary means for determining rules of law within Article 38 of the ICJ statute. First of all, there is no reference of the Commission in that provision. And there is a question of whether it is possible the Commission still to fall within, fall within the gaps of teachings and courts decisions. To remind everyone, of course, this particular provision was adopted, existed in the statute of the PCIJ, and it was included in the ICJ statute. The Commission obviously did not exist at the time, and it was not, drafters were not aware of the potential even of the Commission. And so that may be one reason why they didn't include it. So that doesn't mean that the Commission, in other words, cannot fall within subsidiary means for determining rules of law. Others argue that, of course, they could fall within teachings. It is possible, but I think that the Commission has a bit of a different role because it's a collective body, first of all, and it has a very, very clear institutional, official relationship with governments. So it's not the same as teachings in terms of what the drafters of the ICJ statute had in mind. Again, what I'm saying is that, yes, in principle, the Commission's pronouncements fall within Article 38 of the ICJ statute. But I suppose the second point to make is that I don't think that these are two exclusive positions, that the Commission can only be relied on as a subsidiary means for determining rules of law and cannot be relied on as a supplementary means of interpreting a treaty. I think these are completely possible options.
So,
it depends on what type of function the court has. If it is falling within interpretation, why not rely on the Commission's work as a supplementary means, assuming that everything else is met, as we discussed, the conditions for relying on it.
so let's change the scenario a bit. So it's not genocide convention, it's a customary norm that in a future case that the court is interpreting, and then there comes a question of rule ascertainment. Then we wouldn't be applying Article 32 and supplementary means. Then we were left with this void in subsidiary means, and that's basically all we have. So then in that sense, would we just look at ILC as a subsidiary means of developing the law, or like how would it go in terms of rule ascertainment, in terms of custom?
Yes, so I think, yes, you could say that it's relying on the ILC's pronouncement as a subsidiary means for determining a customary rule. And in fact, okay, the instance that I have given you, and I think if I'm not mistaken, I am explicit to this effect in the article. It is possible, of course, that one interprets the particular pronouncement of the court in a different way, instead of seeing it as a supplementary means of interpreting the Genocide Convention. What the court might have done is instead to consider that in the commentary of the Code of Crimes, the Commission has identified a rule of custom, and as a result, it has relied on the Commission's work as a subsidiary means for determining a customary rule. And so it could have done that, and then used 31(3)(c) implicitly, the interpretation rule of taking any relevant rules of international law for the interpretation of the Genocide Convention. So there are different, of course, steps and routes that the court could have taken. But at the end of the day, the court has done so and has involved the Commission within the interpretive process of a treaty in relation to which the Commission has not really been involved.
So this is quite interesting in terms of, and this discussion, in fact, sort of we've seen, for example, states finally catching on to this term that you've coined, codification by interpretation, and then we've seen Spain, for example, rely in their comments and observations on the draft conclusions on peremptory norms on general international law. So tell us a bit about the context in which Spain used this term, and just as in terms of your, and just to go on to your concluding thoughts, and how do you see this term playing out in the future, and in terms of the ILC's work, and just generally states. Yeah, sorry.
Yeah. First of all, just to say that I was really excited to see that Spain used specifically this term, codification by interpretation, and it used it in its, I think you just mentioned it, in its written observations to the International Commission on its work on use Cogens adopted on first reading. I think there are, I suppose, two very interesting points here. I think, and I suppose the overarching important thing is not that a term has been used. A term has been coined in the first place because it endeavors to show that there are specific legal effects coming from it, and that there is specific legal significance. And so I'm hoping that this term has been useful to states in order to explain what the Commission is doing and what the possible legal effects can be, so that they are much more aware of how they have to be reacting on taking into account the Commission's work. So and the effects that we discussed are that the Commission's work is, the interpretive pronouncements are not authentic and authoritative in that way, and binding and conclusive interpretations, but that could possibly constitute supplementary means of interpretation. And in any event, they give this incentive to states to react, and through that dialogue to clarify the meaning of the Vienna Convention and of custom. And that's one part of the importance that states are now taking note of this. The second part of the importance of why states, or rather of the fact that states are taking note of it, is what it means for the Commission. And I think that the moment states are starting really to eagerly use the term, and also parts of what I was arguing in this article, it puts the Commission in perhaps in a more awareness about its role, its modern role, but also awareness about the methodologies that it is using. And how clear it should be about the methodologies that it's using, what you call more conscious about the methodologies and the function. And that will improve its own work and as a result, its authority.
Right, and that's an interesting point to, I think, conclude on. And thank you, Dr. Azaria, for joining us, and we will see you in the next episode.
Thank you very much. Thank you for making the time.